So thank you two for showing up. Hello internet, you're all awful, you didn't show up, but that's okay. It's finals week almost. We're pumped, we're ready to go. We are gonna start our final review. So first things first, please remember that the tutors are a secondary source. The primary authority of the class is Professor McKee. Her lectures, her slides, your textbook. That's what you're being tested on. If something I say and something she says or the textbook says differ, go with her because she's the one grading you. All right, so what is a paralegal? They're also known as legal assistants. Legal secretaries are different. A legal secretary is going to be at the front desk, taking calls, writing up notes, probably getting some coffee. They're very valuable. They're very important jobs. They're a good first step if you need to get your foot into the legal world. Say you don't have enough experience, you're not going to get a paralegal job. You work as a legal secretary, you're still working in a law office, you're making connections. Paralegal is also someone who is trained to handle substantive legal work under the direction and supervision of a licensed attorney. Now, this is very important to remember. We can't do the law on our own. We have to have directions from an attorney. They're the ones telling us what to go. My old adage is the attorney is the one driving the car. They've got their eye on the road. They've got their foot on the gas pedal. We're the ones sitting in the passenger seat, handing them the snacks and changing the radio station. So we're there to help. We're there to help specifically with legal work. A good way to remember it is if you call out sick that day, the attorney is the one who has to do your work for you. They can't hand it to the receptionist or someone from files or like a janitor or anything like that. Right. So, how do you become a paralegal? You guys should remember this. This is definitely on your first test. You need to complete an ABA certified paralegal program. You need to, if you don't want to do that, you should complete 24 semester units of law-related courses at an accredited institution. If you don't want to do that, if you had a bachelor's degree and you had 1 year of experience under a licensed attorney. So that's sort of what Kim Kardashian is doing as a lawyer right now, is she's learning the law under an attorney. An attorney is signing off saying, hey, they know what they're talking about. Now, this one is really not relevant to any of us anymore, but you can earn a high school diploma or GED with 3 or more years of experience under a licensed attorney earned before 2003. That's technically in the statute, but it's really not relevant to us anymore. It was more meant to sort of grandfather in people who had been working as paralegals for 10, 20, 30 years before California enacted this statute. Pop quiz, do you guys remember what this statute is that tells us how you become a paralegal?
6450?
Yep, Business and Professions Code, Section 6450. That is very important to remember. It will come up throughout your time here at Mount SAC. All right, so, and I think I have 60 slides on this one. It's pretty thorough, so we're gonna sort of rapid fire. But if you guys have any questions, feel free to stop me, be like, hey, I don't understand this. You guys are in person, so you get a custom experience. Okay, so what does a paralegal do? You're going to be conducting client interviews. You're going to be working with the clients as their contact. Remember, if it is going to bill out as $1,000 to call the lawyer for a 20-minute conversation, it's much cheaper, it's much easier to talk to the paralegal and they'll relay the same information that the lawyer gave you. You also may have to locate and interview witnesses. You may conduct investigations. You definitely are going to be calendaring and tracking deadlines. That is what we are good at. It is our bread and butter. So definitely if you're having problems calendaring and you're not quite getting it yet, I would work on that. Being detail-oriented, keeping on deadlines, keeping track of things is one of the big skills that we need as paralegals. You also will be organizing client files. I know you guys are already working with file folders. You're going to have to be doing that thing all the time. More and more, it's going to be electronic organization as technology gets better, but you need to know how to do both. You will definitely be doing legal research. If somebody's bringing you a case, you need to know how you argue it. You need to know how you defend that person, how you get them to where they need to go. You also will be drafting and filing documents. Again, the lawyer's not going to want to sit there and fill out 17 Form 8220Bs when they're just going to hand it to you and be like, fill this out, here's the information, you know it. Hand it to me when it's done so I can look over and make sure you haven't messed it up. And you may get to attend legal proceedings and assist with technology. So what that means is essentially what I'm doing right now. You may be sitting next to the lawyer as they're giving their speech and hitting next on the PowerPoint button. But it is a skill that you guys should know how to do. All right, so what can't a paralegal do? Practice law, give legal advice, or engage in the unauthorized practice of law. Basically, that's our big no-no as paralegals. We are not licensed attorneys. We have not sat for a state bar. We do not have an organization that is regulating us. We are sort of self-regulated. We answer to attorneys, and attorneys answer to the state bar. So if we mess up, it's their fault by proxy. Aunt Susie comes to you and says, "Oh, I know you're taking paralegal classes. I have this issue. What should I do?" What's the only acceptable answer you can say? Exactly. Here's my attorney's card. Give them a call. You are, as Professor McKee's, I'm sure, told you, you guys are a walking billboard. It's very important that you're not practicing law, but you guys are working for people who do. So you want to be able to be on that. And if you still really just, you love the law and you want to give legal advice, then go to law school and become an attorney. That's your only option. Okay, unauthorized practice of law, aka UPL. This is engaging in actions defined by the state as practicing law without a license. You have to be licensed to practice law. Paralegals, luckily, we don't have to have a license to practice law yet. That may change in the future. But as of right now, we're pretty lucky. We don't have to sit for a state bar. Okay, paralegal regulation. Again, that beautiful code section 6450. That's what tells us here in California, this is what a paralegal is, this is what you can do, this is what you can't do. We are self-regulatory, which means we're regulated by statute and attorney supervision. We don't have to pass a bar exam. And if a paralegal violates a rule governing attorneys, it may result in serious consequences for the client, for the attorney, and for the paralegal. I mean, think about it. If you mess up and you've not filed something correctly, the other side makes a motion to dismiss the case entirely, it gets thrown out. Your client gets hurt because, say they were suing somebody for damages, they don't get that money, they aren't made whole again. The attorney gets hurt, they can face anything from severe reprimands and professional embarrassment to being disbarred and losing their license to criminal actions. And I mean, if you mess up that badly, you are not working as a paralegal again. It really hurts you too. So we want to make sure that we are following any regulations that there are and that we, once again, have adequate attorney supervision. All right, so how do you become a lawyer? You've heard all my talk about you can't practice law and you go, that's not for me, I want to practice law. You can get a bachelor's degree and a JD from an ABA-approved law school. You pass a state bar examination, and you also pass an extensive personal background investigation. Now, why do you think that last part's really important?
Don't you not have criminal?
Yeah, because we're in charge of the law. We're in charge. People come to lawyers and they think they know what they're doing. They're upstanding. They're honorable. They're not going to cheat me. They're not going to lie. They're not going to go blab all my information. We want to make sure that the people we are allowing to practice law and have this power over the fates of other people are honest and upright and aren't going to mess around with stuff. Okay, bar associations. These are professional associations. They can be local, state, and national levels. And, they'll discuss any issues and decide on any standards that are relevant to that state. The California Bar, they recently completely revamped our ethics rules as of November. So that's been fun to take the ethics class while that's happening, learning all new stuff. But they're going to be the ones who say, hey, these are the standards that we want lawyers practicing law in this state to uphold. You have to pass bar exams. During the bar exam, they're going to test you on that state's law. They'll also test you on multi-state or federal law. California, you are required to belong to the state bar association. You're not required to belong to any national associations or local associations. However, it's probably a good idea. You can make a lot of connections, a lot of networking opportunity. All right, self-regulation. This means the regulation of the conduct of a professional group by members of the group themselves is how you're held up. In the law, we are self-regulated. We have a group that says this is the standards we're holding our community to. So if you have a complaint, you can file a civil action against somebody, or you can send them to jail if it was a criminal wrongdoing. But if it's just an ethical violation, you answer to the state bar. These establish ethical and professional standards, like I said, and the group has to comply with those standards. You get kicked out of the group, these are our club's rules. If you don't follow the club rules, we kick you out of the club. Now, lawyers can be regulated by the state Supreme Court, the legislature, state bar associations, and the U.S. Supreme Court. So how that sort of breaks down is at the court level, we have cases that judges have decided saying, hey, it's really shady for you to steal money from your clients. You shouldn't do that. With the legislature, they've passed statutes saying it's against the law to do this type of behavior. Or if you're going to call yourself a lawyer, you have to act like this. And then your state bar associations have sort of everything that's that and in between. It's sort of this is how we want lawyers in our association to behave. This is how they need to uphold what it is to be a lawyer in California.
Question?
Mm-hmm.
So that is just the self-regulating for lawyer, but not for the paralegal.
So paralegals are also self-regulated in that.
Under that.
Yeah. So we're regulated by the same laws because we have to obey the same things attorneys have to obey. Because think about it. If an attorney is telling you, hey, go run that stop sign, the attorney is breaking the law by having you do that because they know they're not allowed to do that. So we don't necessarily have a state bar that we answer to, but we have to be directly supervised by attorneys. So they're sort of our self-regulation. An attorney is who we answer to, but that attorney answers to somebody higher up. Therefore, as paralegals, we're being trained to know what those higher up rules are. That way we don't get in trouble. Does that answer?
Yeah, but so we don't have the paralegal association. We don't have that.
We have a bunch of paralegal associations. They're optional. We're not required to register with a state paralegal bar, for example. Only attorneys are required to register with the state bar, kind of thing. Yeah.
Only the lawyer.
Yeah. I'm knock on wood. So far, it's sort of optional and best practice, but we don't have any real regulatory area that we have to answer to. Yeah, knock on wood. I'm sure it's coming. And with that, lots of fees.
Maybe in the future we'll have an exam for the paralegal.
Yeah, I'm sure they will at some point because they're going to want the fees from that. I could get into a whole thing on that. That's a topic for another day. Okay, so where do paralegals work? The most places you're going to be working are law firms. Remember, large law firms are over 25 lawyers. Small law firms are 25 or less. The book doesn't really give you medium law firm classification. It's just large or small. You also may work for corporations like insurance corporations, Disney's legal department, etc. You can also work for government agencies, or you can work for the courts, those kind of things. And you can also work freelance. Now, it's important to remember that if you are a freelance paralegal, you still have to be supervised as under an attorney. So what that means is you've got your shingle on the door, you say, I'm a freelance paralegal. Okay, this lawyer wants me to draft a restraining order for their client. Boop, boop, boop. I drafted it. I sent it back to him. He looked at it. Cool. He gave me $50. That lawyer wants me to draft a pleading. Okay, boop, boop, boop. I drafted it. I sent it back to her. She looked at it. It's okay. She gave me $50. So you're not getting a 9-to-5 job. You're not paid by one single lawyer or law firm or corporation or government. You're working on your own, and you get to pick and choose who you want to work for, but you still do have to work for an attorney. You don't get to just be like, my brother Larry is opening up a consulting firm and I'm going to be his lawyer, because that would be what? Unauthorized practice of law. Exactly. Oh no, the computer froze. Technical difficulties. All right. There we go. It works again. Okay. Compensation, aka them sweet, sweet dollars. Most paralegals are going to be salaried. You're not having to clock in, clock out. That being said, you do have to keep right on track of billing, but we'll get to that in a couple slides. As the profession has grown, the average salary has increased, and this can be affected by the size of the firm or the legal department. I mean, think of it this way. If you're working in downtown LA for a law firm that owns an entire high-rise building, they've got a lot of money. They can give you more money. If you're just working for a single lawyer in West Covina, that maybe they're a couple years out of law school and they're starting their own practice, and it's you and that lawyer and their dog, they probably don't have a lot of extra money to give you a nice beefy salary. Having special skills and experience will get you bigger paychecks. If you're the only one in the office who knows how to work Clio or some software program, or you're the only one who knows anything about e-discovery, then you are suddenly a really useful resource. And when it comes time to salary review day, you get to be like, hey, I'm the only one who knows this. Maybe I deserve a pay raise. Versus if you're just like, I know how to write my name and I can type a word a minute in Microsoft Word 98, that doesn't necessarily make you very competitive. You will also be frequently asked to do overtime. I mean, this is a profession in which there are a lot of hours that get put into it. There's a lot of effort that gets put into it. And as a result, if you're working for something like a government agency where that very much is 9 to 5, you come in here, you do your job, and you go home, you may not have to work as much overtime. But if you're working for a private firm and say it's crunch time and trial's in less than a week, and you have to get the trial notebook prepared now, and oh no, the copy machine's broken, and what do you do? And so now you had to run down to Kinko's and get all this stuff copied, and now you have to, if you're the only one doing that, you're going to be working overtime because you have to meet deadlines. And deadlines don't care if it's your Nana's birthday tomorrow, you will probably be asked to do a lot of overtime. You will probably be asked to do a lot of outside work. But, that's the profession we're going in, and at least it does pay pretty well. All right. Private law firms. The size and structure affects your working environment. Again, if it's a big, huge law firm in downtown LA, there's going to be a lot of office politics. There's going to be a lot more people to interact with. Tiny firm, just you and the lawyer in a potted plant, it's going to be a little more intimate, probably a little more easy breezy. Now, do you guys remember sort of the terms from your last test about solo practitioner, solo proprietor, those kind of things? The look of confusion tells me I should go over it. Okay, so remember, a solo proprietorship means it's a solo practitioner. There's only one lawyer there and they're calling the shots. The single attorney is the business. They're entitled to all of the profits, but also liable for all of the debts. A partnership is an association of 2 or more attorneys who carry on as co-owners a business for profit. So the managing partners are the ones who started the firm. They make the policies. Associate attorneys are just employees. The managing partners are the ones who have the most financial stake in the company. They're liable for the losses, but they also get much more money. That's why making partner is always a good thing with attorneys, because it means you get a big old hefty paycheck. A professional corporation, remember, is formed by licensed professionals. The shareholders are the bosses in that situation, and the profits and liabilities are limited to the amount the shareholders have invested. If you own 50% of a company, you're responsible for 50% of the screw-ups, and you get 50% of the paycheck. If you only own 1% of the company, they're not going to come after. If somebody sues the company, you own 1% of it, and I own 99% of it, they're not going to come after me for $1 and you for $1 million. So the more hold you have in a company, the more you're on the hook for it. If you're a single attorney, that's it. You are the whole shebang. If you're in a partnership, it's distributed a little more evenly. If it's shareholders who are calling the shots, then it very much is profit driven, and it's distributed even more evenly from that. Okay, law office management. So especially in a larger firm, they probably will have a chart like this. It's important to know who's the higher ups and who's sort of lower on the rung. You need to know who you answer to, and you need to know who you're responsible for. Because if, like, Susie the intern messes up, if you were supposed to be supervising her, it's your fault. If you mess up and your boss was supposed to be supervising you, it's her fault. So, it's always important to know sort of where the power structures go. You'll have things like partners who are at the top of the ring. Then associate attorneys are sort of underneath them. Then law clerks are sort of catty-cornered to accountants and paralegals. All 3 of those are going to be sort of professional helpers. You're not just a secretary, you're not a word processor or a librarian or a file clerk. You're not part of the janitorial staff. You have a specific purpose in that company, which is to aid the lawyers. I think I have some more notes in the PowerPoints there. So again, you guys definitely have all learned this stuff already and been tested on it. You should be having flashbacks at this point. But yeah, it is important to know sort of where you fit within the law office. Remember, you are not going to be technical staff or support staff. You are paralegals. You are very much there as skilled technicians, if you will. Right. Now we get to go through there we go. File master. You are going to become a black belt in file management. Some typical files include things like client files, work product files, or form files. Do you guys remember what the differences are between those 3? I'm like, it's finals week, I'll help you out. Client files are how you keep track of what's going on with a client's case. They're specific to each client. If you come in and I have a case going with you, you have your own file. You would have your own file. Betty with the dog bite case has her own file. It's very specific to each client, and updating those client files is how you keep track of where the case is going. Work product files are going to be things like copies of research projects, legal memoranda, pleadings to refer to in future projects. As Professor McKee says, don't reinvent the wheel. A firm you're working at will likely have work product files where they say, okay, here's research on the current dog bite statutes in this county. If you have somebody come in with a dog bite case, rather than have to send you out and go do all of that research on, from scratch and take up a bunch of time, if they have a big fat file that is like the current dog bite statutes, you can look at that first, save yourself some time. Form files are going to be blank versions or templates of pleadings, summons, memorandums, etc. The judicial council forms, they'll probably have, links to those. They're blank versions that you get to then plug your own information in. Because while it's very useful to know how to create a pleading from scratch, it takes so much time having to get all the pleading paper and all the numbers aligned. Oh, it's so hassly. So rather than have everybody do that new every single time, they have blank versions that you can just go right into and keep doing your work. All right, confidentiality is one of the most important professional obligations that we have as paralegals. It's recognized by common law, and there are criminal sanctions for violating confidentiality. This is just, if there's one thing I can impart, no, if there's two things I can impart on you guys. You can't practice law, and you have to keep your mouth shut. Confidentiality is it's the most important thing that you should hold dearer than your one true love. Clients need to know that they can trust their legal team, or they might not tell you everything you need to know. So my example is, I don't know if you guys have ever seen the movie Legally Blonde. If you haven't, you should watch it. It's adorable and fantastic. But in it, Elle Woods, our plucky protagonist, is a law student, and she's been hired on to this law firm as a sort of a summer intern. They get this crazy huge murder case that the lawyer is taking on. The lady who's being accused, they say she murdered her elderly husband for his money. She's this big shot Hollywood type, and they say, hey, we need to know an alibi so we can help you. And she says, no, I'm not going to tell you guys. I have an alibi, I didn't do it, but I'm not talking to you because I don't trust you. And so I don't want to spoil the movie because everyone should go watch this movie. You guys are law students now who should invest in it. But she basically goes to talk to this lady in prison and sort of gets the alibi out from her and figures it out, and a whole thing happens. I don't want to spoil it for you. But this client didn't trust her lawyers, and so it's, I don't trust you not to tell my secrets, so I'm facing jail time. You don't want that situation. You want your clients to know, if I tell you something, barring very specific circumstances, you are taking it beyond your grave. You're going to get up to heaven, and St. Peter's going to be like, hey, so what was the deal with that client? And you're going to be like, sorry, dude, I can't say. It's confidential. Confidentiality continues beyond the client's death. Basically assume, again, barring very specific things that we're going to talk about in the next slide, you have to keep your client's information confidential forever. So, again, the takeaway, confidentiality is ridiculously important.
But unless the case is public in the internet or something.
Yeah, so if something is public knowledge, for example, if a deposition becomes public, people can read about it themselves. That is public knowledge. That being said, best practice is still don't say anything. Always treat everything as 100% confidential unless a judge tells you not to. Is sort of the best the best way to go about it. So there are exceptions to confidentiality. If a client consents, so I tell you, hey, you're my lawyer, you can tell my husband, what you're talking to me about. You don't have to keep it confidential from him. I've given you consent to reveal that information to a specific person. Or if I'm like, tell the world, I don't care, then I've given you consent to break that confidentiality. Implied authorization. In order to carry out your representation, sometimes some certain confidential information has to be disclosed. And so it's sort of an implied authorization that if in the course of defending my interests, you have to disclose certain information. For example, in insurance claims, I need to let your insurance provider know certain things about your case. It's implied that I have your consent to do that. If the client intends to perform a harmful act, meaning you're working in family law and your client comes in and they're like, oh, oh, my wife took everything from me. Here's the gun. I'm going to shoot her in the face. You don't have to keep that confidential. You need to be like, cool, wait right there. I'm going to go into the next room. And then you're like, boop, 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 boop. Hello, 911. Like, if the client intends and you believe they intend to carry through with a harmful act against themselves or someone else, then it's okay to break that confidentiality. The idea being you are preventing a crime. You are not allowed to aid your clients in the committing of a crime. So that's sort of where that comes in. If you're defending against a client's legal action, so for example, a client sues you for malpractice because they say you didn't file the case right and you ripped me off, you're allowed to be like, hey, no, this is what I did, because you're allowed to defend yourself. That being said, you're also not allowed to bring up all the sordid details of the client's past. You're allowed to defend yourself against a client's legal action very narrowly and specifically. But as a rule of thumb, always keep confidentiality except in certain occasions. All right. So, common law. I know I talked about that earlier. Common law is the body of law derived from the customs and judicial decisions of the English courts. The English colonies, if we were ruled by England at one point, we probably have an established common law system, because essentially England brought that over with them when they decided to go like tootin' about the world. Interestingly, in the U.S., our system of law is based on common law, except for one state. Do you know which one that is? Louisiana. Yeah, they are under Napoleonic Code. And that's because they were owned by the French. This is, again, a major source of U.S. law. So part of the thing that we keep from this is judges have to base their decisions on earlier cases. Do you guys remember what it's up there. So hopefully you remember that is the concept of precedent, or stare decisis. So, stare decisis, to stand by things decided. Again, I just like to think stare, stand, decided. Helps me remember it. This is the doctrine of precedent. Courts are obligated to follow earlier decisions of past or higher courts. So precedent is the decisions that furnish the authority for deciding later cases with similar facts. So what this means is we want our court system to be fair. We want to sort of know what we're getting. If every single time in every other case that's like mine, the judges have decided one way, I want them to keep deciding the same way. Now, judges can break from precedent under certain very specific conditions again, but on the whole, most judges like to hold with precedent. We like to say, hey, this is fair. We've already decided this is the way we're doing things. It doesn't get to be wishy-washy and custom for everybody. It's uniform. So, when do courts depart from precedent? If the court decides it's wrong. So, for example, Plessy versus Ferguson, they overturned the precedent, or Brown v. Board of Education, they overturned Plessy versus Ferguson. Finals week, my brain's all over. And so they decided separate but equal is not equal. We're steering away from that precedent. It's wrong. We're changing it. They also may decide to change if technological or societal changes make it inappropriate, obsolete, or outdated. So, for example, if precedent said it's illegal to, or say precedent said you're allowed to go in someone's mailbox and see what letters, you can't open the letters, but you can see what letters are in there. And they decided that's our precedent. But somebody brings up email. If you go into my email inbox and you're scrolling through, is that the same thing? Is it different? Courts might decide that technology has changed so much that we can't give the same logic. We can't apply the same rules to this scenario. It's not on the slide, but also in cases of first impression. So what that means is the courts have never seen anything like this before. This is the first time they're ruling on it. They are the ones who have set the precedent. Obviously, if there's no precedent there to follow, they don't have to follow it. they get to be number one. Okay. Jurisdiction. This is the authority of the court to hear and decide a specific case. Courts have to have jurisdiction before it can hear a case. And there are, as you see, a bunch of different types. I know we went over those on the last slides. But it's really important to remember the courts need to have the authority to make a decision. Think of it as like the bratty toddler, and the stepdad yells at them and they're like, "You're not my real dad." Essentially the court needs to be able to say, "Yes, I am your real dad. Go to your room." The courts need to have the authority to hear what's going on. All right, so you guys remember this dreaded court system diagram. It will also be with you forever. So I would go back over it, sort of brush up on it, make sure you understand the differences between original and appellate jurisdiction, between state and federal, how things go to the Supreme Courts. Definitely remember the writ of certiorari. Practice saying that one, that's fun. Remember what circuit we are in the Court of Appeals. Remember what district we are. Remember how many justices are on the California Supreme Court versus the U.S. Supreme Court. Just sort of generally make sure you're brushed up on that. It could not hurt. I'm just saying. Okay, so why file state versus federal? You're going to really determine the costs and the rules of each court. Is it going to be cheaper to file this thing in federal court where it might be faster versus state court where it can be anywhere from 2 to 6 years? Also the jury pool. Are you going to file something out here in California where it's probably pretty liberal and, you have a real hippie case and so you want really liberal people to sit on the jury? Or are you maybe going to take it somewhere else where maybe they're more conservative and so you want that kind of jury pool? And again, length and time to start a trial. Federal courts can be much faster because they get to be a little pickier and it's a little more streamlined. And your chance of winning. Are you more likely to win if you make this a federal matter? Are you more likely to win if you just keep it with California's laws? These are all factors that you can go into deciding whether you file state or federal. Now, do you guys remember the type of jurisdiction that would allow you to try and decide state or federal? Starts with a C. Concurrent. Good job. Fun bonus pop quiz. Okay. Procedural law. This is essential in the litigation process. You guys are just an intro. I don't know how many of you are taking civil procedure right now. It's fun. It's something that you guys really need to hammer home. When lawyers go to law school, they get big, huge books of cases, and they learn the concept of laws, and they learn definitions of things like burglary or mayhem or what have you, and they learn all of this real conceptual, here's how I look at things. They don't necessarily learn if you mail a summons, you have to give them 5 extra days. Or if it says, calendar days versus court days, you can't choose weekends. Or I know this is the form I need to do. Or I know pleadings have to be exactly 28 lines long. That's all procedural. And that's what we're learning here at Mount SAC. And that's what's going to make us a valuable, valuable resource. A lot of lawyers, when they first get out of law school, if they don't have this sort of procedural training already, they're sort of at a loss, and so they have to actually work under other lawyers to get that procedural training. The procedural rules of each court are what dictate this, and they're going to specify what has to be done in the various stages of a court case or a motion or what have you. Each state has its own rules of civil procedure. We have ours. It is many, many volumes long. The federal rules of civil procedure cover federal cases. That's pretty straightforward. And the rules of procedure differ in criminal versus civil cases. So criminal procedure is going to say, hey, this is what you have to do in this instance, versus a civil case where you're just sort of suing someone is going to have different types of procedure. And so it's good to know both. If you're going into criminal law, obviously you'll have more experience with that. If you're going into civil, you'll have more experience with that. All right, cast of characters. The parties are the persons involved in the judicial action. The plaintiff is the person bringing the lawsuit. Again, I like to remember it as the plaintiff complains. The defendant is the person defending the suit. Again, the defendant is defending themselves. And then when you get into the appellate level, the appellant is the person appealing the decision, and the appellee or respondent is the person against who the appeal is filed. So we go to court, and it's you versus me, and you win, and I'm upset with that. I appeal. I am then the appellant, and you will be either the appellee or the respondent, because you're saying like, hey, don't tell them to reverse this decision. It needs to stick. Judges can also be known as justices. They are the impartial person overseeing the trial. All right, so now nitty-gritty time, the initial client interview. This is going to be most often conducted by the attorney, and it will explain his or her services, agree to what they're representing you in, set the fees, and the attorney will probably give some legal advice there. Again, remember, we can't do that last part. We are not allowed to give legal advice. Even if somebody comes in and we've seen their case a million times before and you know exactly what the attorney's going to say, you still can't say it. In the initial client interview, you're also collecting facts. It's ideal if the paralegal does attend this, because then you and the attorney are on the same boat and you sort of know where you need to go. And you'll also have release forms that you may need the client to sign. So any subsequent client interviews or any interviews beyond that initial first interview, you may need further information from the client. Maybe they came in because the neighbor's dog bit them and they want to sue them. And I'm like, well, what type of dog is it? And they're like, I don't know, I gotta check. And so they come back in later and they're like, it was a pit bull. So during any client interviews, you always need to disclose your non-lawyer status, meaning you need to tell them, I'm not an attorney, I can't give you legal advice. Any advice I'm giving you is coming directly from the attorney. I'm just a conduit. You also should tell the client what kind of documents they need to bring. If you need the client to bring in the pink slip of their car or their insurance information, you need to tell them to bring it. That way, you're not hamstringing yourself, you're not slowing everything down. You also always want to send a follow-up letter confirming the date and time of any further interviews. Always try and get stuff on paper. That way, if there's a mistake, you can clearly point to what was typed. All right. Preliminary investigation. Oh, so many slides. This is a key part of pretrial work. This will include things like the police report, medical records, employment data, eyewitness accounts. You may have to locate the defendant, and you definitely will be creating the litigation file. If you have comprehensive, well-organized records of the case, it makes everything much more smooth. And, you should create an investigation plan, and you should make sure it's approved by the attorney so you're not just floundering around and wasting your time. If you're like, I'm going to go track down that witness, and the attorney's like, why? I don't need them. You don't want to waste time. Okay, so this is going to be an example of a complaint. This is a pleading drafted by the plaintiff. Again, the plaintiff is complaining. The caption will include the name of the court, the title of the action, the names of the parties, the names of the document, the court's file number or docket number, just sort of the basic, hey, this is what's happening, this is where we are. The jurisdictional allegations are going to sort of start off. Those are going to be sort of addressing any diversity of citizenship. Basically, you're telling the court, this is why you have jurisdiction, this is why you should listen to my case. Now, the body of the complaint is going to be sort of the general allegations, advocate the plaintiff's position. That's basically where you're like, the neighbor's dog bit my client, and that's why I'm suing her. Here's the evidence. The prayer for relief is what you want to happen. we pray that the court awards my client, all her medical bills and an additional $100,000 for pain and suffering and, a shiny gold piñata, whatever you're wanting to have happen. And then the signature confirms that the attorney has read the complaint and that the facts alleged are true to the best of their knowledge. So that last part's important. If something turns out to be false, you're not claiming that it's true forever. This is hardcore facts. You're saying, as far as I know, I've done my best to make sure this is true. Okay, so the answer is the defendant's response to a complaint. You can go 3 different ways. You can answer with an affirmative defense. So this doesn't deny the plaintiff's facts, but it attacks the legal right to bring the action. For example, if it's outside the statute of limitations, you're saying like, hey, you don't even need to hear this case. It's outside the statute. Just throw it out. They're wasting your time. You can answer and counterclaim. And so the counterclaim is a claim made by the defendant against the plaintiff, aka a reverse lawsuit. That's sort of like, you can't sue me, I'm going to sue you back, that kind of thing. You can also cross-claim. So what this is that the defendant asserts that claim against another defendant. If I throw a book at you, you're going to sue me. You're probably going to also sue Mount Sac as my employer. Mount Sac is then going to cross-claim against me, being like, hey, you were a lousy employee and now they're suing us, we're suing you back. So there's there's 3 things you can do as an answer. All right, motions. There's a bunch of different motions. I'm not going to go through all of them because, again, hopefully you guys get access to these slides and so you can sort of scroll through, and also this is all in your book and your class notes. But there's all kinds of motions that you will be making in civil cases and also criminal cases. All right, e-filing. This is the new frontier. It is the wild, wild west for paralegals. E-filing reduces time and paperwork, 24 hours a day, 7 days a week. Some courts now require e-filing. They don't want to have stacks and stacks of motions and forms. They want you to submit it and let the system start rolling. All right, discovery. It is not filed in court unless it's an exhibit for a motion to compel or something like that. Discovery has to be shared with all parties. Again, we want our system to be fair. We don't like surprises in the court. We don't want those like, aha, smoking gun, I found the murder weapon, here it is in court for the first time. No, that's how you get your case thrown out. We want everybody to have a fair shot. We want, you have all the evidence, I have all the evidence. Now we're arguing what's best for our clients respectively. Parties who don't comply with discovery can be sanctioned. And sanctions are, essentially like the court fines you. The court says, hey, you screwed up. The court may say you're suspended. You don't want sanctions. Those are bad. Different types of discovery include interrogatories, depositions, requests for production, and physical examination, aka an inspection demand, or requests for admissions. So, we're going to go into those last couple ones. Interrogatories, also known as ROGs, are written questions between the parties only. So that one's important. I, as the defendant, can send the plaintiff ROGs. The plaintiff is definitely going to send me ROGs. They have to be answered in writing under oath within 30 days. So if, this is where you get those gotcha moments. If I send you an interrogatory and it says, where were you last night? And you're like, I was at home. And it turns out you were shooting somebody up. Then, you've lied under oath. And that's a bummer. You are limited to the number of questions. These are governed by the California Code of Civil Procedure. You guys will definitely get into this in your civil procedure class. You also can have things like form interrogatories. Those are a set of sort of Not mandated. They're forms. So they're a set of generic questions that you get to check off and say, hey, I want you to answer 1, 7, 5, 9, and 33. So those don't fall under your limited number of questions. So those are really good for like the defendant's name, any witnesses they know of, did you have medical insurance, sort of basic questions that you don't want to waste your super special specific ones on. All right, depositions. This is oral questions of parties or witnesses. And again, oral questions, they're answered orally, meaning I sit down and I ask you questions and you're sitting there and you respond to me. You are under oath. This oath is administered by a court reporter if you have them there. And transcripts can be made of the testimony. And these are also governed by California Code of Civil Procedure. And more depositions are being filmed. It's real spicy evidence if you can play that in court of the witness being fidgety and suspicious and they didn't want to answer. But that is also sort of agreed upon by parties and governed by civil procedure. All right, request for production and physical examination. FRCP 34 authorizes the request of evidence from the other party. You can request permission to enter another party's land, pardon me, to inspect, test, sample, or photograph items. So, for example, if I'm suing you because you have a ditch in your backyard and I was running through your yard last night and I fell into it and I'm like, that was a dangerous ditch. You're going to have your lawyer, I'm going to have my lawyer show up and want to photograph the ditch for evidence so I can show this is why it was dangerous. Requests for production and physical examination are made on the parties only, and they have to be answered within 30 days. All right. So some requests for admissions can be requests for admissions are written statements also sent to the parties only, meaning the plaintiff or the defendant, not to any witnesses. And so these are admitted or denied. Admit that you own this dog. Admit that it's a pit bull. Admit that it bit my son. Admit that you saw it and you didn't do anything. Admit that you never put a leash on him. Those kind of things. Where if the other party admits it, then the court treats it as fact. Hey, you said this, they admitted it, it's the truth. So if you get the other party to admit to doing the wrong, then bam, you've won your case. Now, it's 90% of the time not that simple, but Professor Blade always has his what he calls his Lindbergh baby question, which is you throw in a admit that your client is lying about this whole thing and my client did nothing wrong and they should not pay anything and this case should be thrown out. If the other party just goes through and they don't respond to these, you can have the court deem anything they didn't respond to as an admittance. And if they admit to essentially, the big aha, you did it question, there's your case. So these are always really important to sort of get a grip on. They are also under oath and in writing. You do have a limited number. And again, admitted or unanswered or late responses can be deemed admitted at trial. You petition the courts to deem these admitted, and if they grant that petition, then they're admitted. All right. So some advantages and disadvantages of discovery. Some advantages are it preserves evidence from witnesses. If part of the evidence is this crashed fender bender, if I don't have any pictures of the fender bender and then you go and you get the fender replaced, when it comes time to trial, maybe 2 years later, then if I have no evidence of that crumpled fender, it's a he said, she said. He said, she said. That one's fun. It can also lead to an out-of-court settlement. If you're talking with the other party and you're like, we have proof that, we saw you're claiming that you have a broken foot from this, and I saw you dancing on a table at a bar yesterday. They're going to be like, maybe we'll write a check and just get out of here. It also prevents surprises and narrows the issues. If both sides end up agreeing, we've seen the evidence, we both agree, that the dog bit, my dog bit your kid. Now we're arguing over how much fault it was. I now don't have to worry about proving the existence of the dog and who it belonged to. We get to really focus in. It also safeguards privileged information. So, like, if you have evidence of something, but it's privileged, then you can sort of be like, hey, we're keeping this privileged. We know what happened. It's the old school, I want to talk, but I'm afraid the mafia guy who's the defendant's going to whack me. Like, if I've gotten the evidence, we have that testimony preserved. Now, some disadvantages: gathering evidence and the discovery process in general can be very expensive. I mean, if you're having to hire investigators, if you're having to go talk to witnesses, you're having to fly to some other state to do a deposition, you then have to hire a court reporter to transcribe it. Costs can start to add up. You can also get to discovery overkill or abuse. The old cliche is, I say, oh, I want all of your files from like the evil bank that I'm suing, and they send over 2 semi-trucks full of banker boxes because they're like, you wanted our files, and the one file I need is buried in the middle of all of that. It's going to take me a decade to get through all of that. That's a way people will hide discovery sometimes. You can also get into discovery disputes. If parties aren't cooperating with each other, I might say, you can think of, the thing with Mr. Trump's tax returns. One party is saying, hey, we want to be able to look at this. Another party is saying, hey, no, you don't get to look at this. And so that can sort of stall things out and preventing things from going further. And again, like I said with the banker boxes, you can also get discovery abuses, where it's people inundate you with files, hoping you won't say anything. If people are shredding discovery, that's like ridiculously not good to do. But it also prevents that from being found. All right. Subpoenas. Subpoenas are documents commanding a certain person to appear at a certain time and place to give testimony, aka show up at the Pomona courthouse at 8 a.m. We want to hear what you have to say. You should always issue subpoenas to witnesses, even friendly ones. Just because it's an official, remember, you have to be here. That being said, make sure to warn any friendly witnesses when a subpoena is coming. You don't want to upset them and then get them to clam up or freak out. All right, interviewing a witness. Paralegals frequently interview both clients and witnesses. Learning how to conduct interviews and investigations is an important part of preparing for your career as a paralegal. And it is, if you can conduct really good interviews, it's going to set you apart. A good interviewer has interpersonal skills, communication skills, questioning skills, and listening skills. So interpersonal skills might be, be hospitable, be kind, keep everything confidential, be compassionate. You're there for the person, they feel like they can trust you. Communication skills. Avoid using fancy legal terms. Use a language the interviewee can understand. And, really make sure that you are actively listening to that interviewer, or to that interviewee, I'm sorry. You're getting all of the information as they understand it. Questioning skills. Have a list of topics you need to cover, but those questions should be open-ended. You want the client to fully explain themselves. You want to corral them, you don't want to get off topic, but they really need to explain themselves fully. And of course, listening skills. You need to learn how to listen attentively, provide appropriate feedback when it's needed, control the flow of the interview, but you really want that client to not feel that you're like, You want to engage with them, you want to keep the rapport going, you want to get as much information out of them as you can while keeping them as calm and friendly as possible. All right. So, before the interview, you should discuss with your supervisor, who will be the attorney. Again, it's late. I've been having you guys do this for a while. It's fine. Discuss with your supervising attorney the goals of the interview, the type of information you need to obtain, or the topics that they want covered. Remember, you are acting under their supervision. They've said go fetch, and you say, okay, I'm going. You should have a checklist or a standardized interview form ready. This way you're sort of like, oh, I'm blanking on what else I need to check. Okay, I remember to talk about this. But remember, you have to remain flexible. And if you're asking a standard question and then you're like, oh, and your father's name is, and they're like, I never knew my father. That's when you're going to be like, hold on, what was that? If it sounds like it's something that's going to be interesting and lead to more evidence, you need to be able to ask any follow-up questions. Be ready on the spot. All right, so there are all types of questions. Open-ended questions are a broad, exploratory question that may elicit a lengthy response. You're going to be using this with friendly witnesses and clients. What, in your opinion, caused this? What do you remember happening? How did that make you feel? Those really broad sort of questions. Close-ended questions, on the other hand, are questions that are phrased in such a way that it elicits a yes or no response. These are used to clarify a witness's statement, or with adverse or reluctant witnesses. But didn't you just say that you owned this dog? Well, yeah, I did. And didn't you just say that you owned this dog for a year? Those are very specific that you're going to have yes or no answers to. Those can also verge on this next one, leading questions. Leading questions are phrased in such a way that it suggests the desired answer. In courtroom dramas all the time, you'll hear, objection, they're leading the witness. And so what that means is you're saying like, well, isn't it true that, you used to work for this person, but you secretly hated them? You're really trying to get a specific response out of this person. You can use this with adverse witnesses in interviews or during cross-examination, specifically because you're trying to confront something they said during examination. Hypothetical questions are questions that ask the interviewee to assume certain facts and forming an answer. You're going to be using these with expert witnesses in interviews and during the trial. It's usually a hypothetical question. If a 70-pound dog ran at a toddler and bit them on the arm, wouldn't that arm probably be broken? I'm asking you, the veterinarian, and you're like, yeah, that probably would happen that way. And I'm like, haha, look, that's what happened. Hypotheticals are really to experts to sort of get a correct assumption. Okay, recording interviews. You have to obtain permission from your supervising attorney and the person being interviewed. If they say, no, I don't want to be recorded, guess what? You can't record it. Some benefits of recording, as you at home sitting in your pajamas can probably attest. It helps reduce the need to take extensive notes. The audio file can be transcribed and listened to later, like when you're in the shower or on the car ride here to take your final. And you can show the interview to other members of the legal team. If it's a deposition that you're interviewing, you may be using that as evidence during a jury trial. If you're like, oh, but didn't you just say, press play, and then there's the person sitting on the witness stand blown up, then they're like, yes, I totally did it. And you're like, ha ha ha. So, it can be very dramatic. There is a downside, however. This can make a lot of people uncomfortable, which makes them less willing to freely disclose information. The idea being, if I've got a recording of me saying something, I don't want to say the wrong thing in case it incriminates me later. All right, summarizing interviews. You should review all of your notes and any recordings that exist. You want to summarize right away. You don't want to wait. You want it all to be fresh in your head. That way you're getting the most accurate summary. And you want to note your impressions of the subject as well as any nonverbal behaviors. If I'm just giving you yes and no's, but I'm sitting there fidgeting and then you asked a really suspicious question and I went, oh, that's going to be nonverbal, but you want to note that down. Like, subject flinched and gasped when I asked if they owned a dog. That's going to be something that you're going to want to track down later. Okay. As with different types of questions, there can be different types of witnesses. You can have expert witnesses. These are witnesses with professional training or substantial experience qualifying them to testify as to their opinion on a particular subject. Think medical examiners, doctors, you know, science technicians, what have you. Lay witnesses, on the other hand, are just witnesses who can truthfully and accurately testify on a fact in question without having specialized training. So I couldn't specialize on the workings of a car, but I can tell you that if a car's driving by and it doesn't have any wheels on it, that something's happened. You know, I don't need a lot of training to realize that was suspicious. Eyewitnesses can overlap with that. They are a witness who testifies about an event that they observed or experienced themselves. So, you know, I was standing on the corner and I saw this happen. I was in my home and this person broke in and pointed a gun at me. You're having a direct experience and you're sort of retelling what happened while you were there. A friendly witness is a witness who's biased against your client's adversary, aka sympathetic to your client, meaning they like you, they want your client to win. A hostile witness, on the other hand, is a witness who's biased against your client or friendly to your client's adversary, aka they don't like you, they don't believe you, they want you to lose. So you should assume each witness that you interview in an investigation during, the course of a case is a potential court witness. You need to make sure they're reliable, competent, and credible. You want to put somebody up on the stand who is going to benefit your case. You don't want them thrown out because they're real shady and they probably lied in the past. Because the jury's going to say, well, if they lied in the past, why, how do I know they're not lying now? And, you want whoever you're presenting as a witness to be seen as telling the truth. Okay, preparing your witness or your client. So there are some specific can and can'ts when it comes to talking with your client or your witness before a trial. You can prepare them for the trial experience. What that may mean is, okay, we're going to have you come into the office and we're going to sit you down and I'm going to pretend to be the other side and I'm going to start firing questions at you and I'm going to yell at you and I'm going to get you used to what might happen so you don't get nervous, so you don't freak out. You can tell them what takes place during a trial, such as, we'll come in and the bailiff will say, all rise, and we rise, and then we sit down. When we call you up, you'll put your hand on the thing and you'll say, I swear I'm not a liar. And so you're like walking them through what can happen. You definitely want to instruct them how to dress or conduct themselves. For example, if your witness, in their normal lives, they swear like a sailor, you're going to want to be like, remember, no 4-letter words. We're trying not to give the jury any reason not to like us. Pardon me. You can be like, when you're testifying, I want you to look directly at me, or I want you to look at juror number 3. Sort of get them ready for court and how to present themselves the best way possible. Now, you cannot tell your client or a witness what to say or not say. You're not allowed to be like, don't tell them you killed him. I mean, if you're in that scenario, you probably have already said, don't tell them you don't kill them. You don't want to tell them to lie. If they're like, you don't want to tell them to withhold evidence. If you have a witness and they say, oh, well, I have a picture of your client running into the other car, you don't want to be like, maybe delete that from your phone. You're not allowed to essentially commit crimes. You're not allowed to tell someone what to say, what not to say, when to lie, that kind of thing. All right. Again, there are also a lot of different types of evidence. Evidence specifically is anything that's used to prove the existence or non-existence of a fact. Direct evidence, obviously, is direct. It directly establishes the existence of a fact. I have this copy of your registration papers for your dog. This is direct evidence that you own this dog. Circumstantial evidence is indirect, offered to establish by inference the likelihood of a fact. Meaning, I see that there's a dog bowl and a dog house in your backyard. So I can infer that you probably have a dog because you have a dog bowl filled with food. Hearsay is testimony given in court by a witness who relates not what they know personally, but what another person said. Well, I heard from Becky that Susie said to Karen that Hector really likes me. Like, it's, lots of middleman stuff. Now, The reason we don't necessarily want hearsay is I don't want to hear what Karen told Becky told Susie. I want to go straight to Karen. I want to go right to the source of it. Now, hearsay can be allowed in certain specific circumstances, but on the whole, we want to go directly to the source. We don't want friend of a friend of a friend kind of thing. All right, trial notebook. This is going to be one or more 3-ring binders containing trial-related materials separated by tabbed dividers. These are going to hold key materials. Your attorney will inform you what to include or how they want it organized. And you're obviously going to be creating things like an index for easy access. This is essentially scrapbooking for the law. This protects original documents because trial notebooks contain copies only. But you want to be able to, when you're sitting in court and the lawyer says, give me a sample and, give me page 3 of their deposition. You don't want to be like, hold on, let me dig in my purse and let me dig over here. And, oh no, I left it at the office. You're going to be like, sure, flip open, thud, flip, flip, flip. Here you go. It's to help keep everything organized and together. All right, trial technology. This is, again, an area where if you can really embrace this, you're going to separate yourself from the pack. This can include digital records and video. Some perks. You can access thousands of documents quickly. Digital video and CD recordings help make a big impact. Trial presentation software like mixed media presentations, PowerPoints. They can be more visually stimulating and engaging. They can have a more oomph. And, you also need to be aware of your local rules of court, what they allow and what they don't allow. All right, so again, you'll have this in your notes in your book. You want to have a trial prep checklist that details what needs to happen 2 months before the trial, 1 month before the trial, the week before the trial, the day before the trial. These are the crunch times. This is probably where you're going to be having a lot of your overtime. You as paralegals are essentially in charge of the organizational side. You need to keep everything together, organized, up to date, on time. You absolutely don't want to miss, discovery deadlines, evidence deadlines, those kind of things. Anything that's going to make or break your case, anything that the other side can use to get your case thrown out. You really need to keep everything up to date. So a pretrial conference is where attorneys for both sides meet with the trial judge. They want to explore the possibility of resolving the case. This is also where you're going to determine how the trial is conducted. You're going to be clarifying any issues in dispute and establishing ground rules. So if both sides, for example, say, we're not going to argue that your client owns the dog, we've established that. So when it comes up in court, we're not even dealing with it, we're admitting it. Or, for example, if the other side says, I don't want to allow questions of whether my client had insurance to come up, it's not relevant here and it's going to prejudice the jury. So they argue, the judge says, okay, you're not allowed to bring up whether the other side had any insurance during the trial. Somebody else brings it up. You can be like, objection, we agreed, we're not bringing up insurance. This is also where they'll hear any motions in limine, which is, as the example I just gave, motions to limit evidence. So these pretrial conferences are really where you're sort of like setting the rules for the battle that's about to occur. Alternative dispute resolution, or ADR, is a real bonus. People are going to want to use ADR because litigation is expensive, it's adversarial, and it's time-consuming. I may not want to wait 5 years for this to go to trial. I may not want to deal with the other side hammering away at me and destroying my character when I can engage in alternative dispute resolution, sit down with a mediator, hash it out with the other person, reach a solution outside of courts. About 95% of cases are settled before trial. And so this is really meant to sort of help speed things along, keep the courts running. You don't want to have situations where it takes you 10 years to hear a case. You want to keep things going. So there's different types of ADR. I'll let you guys go over them as you will. Again, these are all also in your own notes and lectures and junk. Mediation can be binding or non-binding, depending on what both sides agree to. So what that means, if it's binding mediation, whatever the mediator, the arbitrator decides, that's what you stick to. If it's non-binding, then it can be, okay, the mediator says, it's going this way, and the other person says, I don't like that, I'm going to try my luck at trial. All right, so settlement.
Question.
Yeah.
So, if after the mediation, if they still argue, so they can like keep going to do the trial.
Yeah. So if it's non-binding, meaning you are not locked into what happened, you can go straight on to trial. If it is binding mediation, which it can be in some cases, then it's essentially like a mini trial, and so what's decided is decided. So it depends on the type of mediation.
But before they do the mediation, the judge will decide you want bind or non-bind, right?
No, so ADR or mediation is essentially, we haven't gotten to trial yet. This side and this side are sitting down with a mediator, listening to both sides, arguing, seeing if they can come to a resolution.
Yeah.
In certain things like contract agreements and those kind of things, there can be clauses which say, you agree by signing this contract to deal with binding arbitration.
Oh, yeah.
And so that means we have to go talk to this arbiter and they're going to decide our case.
Yeah.
But other things, you're going to go to mediation because it's like, a year before trial, and the other side is like, I have rock hard evidence, so we're going to go to mediation. We're going to talk to the other side. We're going to show them how strong her evidence is, and they're going to cave and they're going to settle. And so then, we've agreed out of court, this is what's happening. We don't need to go further with the trial. So it's that sort of like, rather than have to go through the whole trial, it's somebody being like, let's skip to the end. Let's decide this is what we're doing. So essentially it's kind of the like cheating fast track highway. Because again, the courts are so full that anything we can get settled and off of the dockets, the better. Speaking of settlement, did that answer your question?
Yeah.
Okay.
And the arbitration, then that's the end. After they discuss and then they get the solution, and then the end. They cannot go further.
So it depends on the type of arbitration. If it's binding, then that means, yep, that's the end. You guys agreed to this. It's settled. If it's non-binding, then say one side doesn't like what happened, they can choose to sort of be like, nope, we're still going on to trial. So it's kind of like if trial were a marathon, you've started off and you're running and you're running and you're running, and then you both decide, okay, we're going to take a 5-minute breather. We're going to talk. You could decide, hey, we're done running. We're going to call it here. Like, the end, we've hit the finish line. One side may decide, though, I don't like this. I'm going to keep running. And so they keep on running towards trial. Hopefully that made sense.
Because I think the arbitration is more serious than the mediation.
Yeah. So mediation tends to be more like both sides are sitting down to talk with a mediator who is really like, I don't care if you win, I don't care if you win. My goal is to get everybody to meet in the middle and sort of walk out of here with an agreement. Arbitration is really you're sitting down there and actually listening to the things and saying, no, you win, no, you win. So it's sort of a level of whoever is that person in the middle, do they just care about getting everybody to agree, or do they care about, no, this is how we should go? It's sort of how the difference is, how it breaks down. Again, see, this is why you show up to these things. You get to ask those fun questions that were not on my slides. So settlement. Settlement is an out-of-court resolution to a legal dispute, which is agreed to by the parties in writing. And it can be reached anytime prior to trial or during a trial. If you're going through trial and then you're just like, my client is done with this, they want to settle. They don't want to go through this anymore. You can do that. One party gives up the right to initiate or continue legal action against the other in return for a sum of money. So I've brought an action against you. You're like, hey, here's $1,000. Let's settle this. I've given you some money. Let's have this over. If I accept the settlement and I say, okay, I'll take that $1,000, I no longer have the right to continue suing you. I've basically essentially been paid off. I have received, the settlement agreement. I wanted stuff to happen and it's happened, and now I say, okay, I'm done. We're dropping this. It's done. And it needs to be approved by the court. They don't want to see people taken advantage of. They want to make sure it's fair and equitable. All right, jury selection, everybody's favorite topic. A panel of potential jurors is randomly selected by the court clerk and assembled for review. Some trials require 12 people. Some civil trials can have as few as 6. And so when you're going through, you want to be able to choose people who you think are going to go in your favor. And the other side is going to be choosing jurors who they think will go in their favor. And in theory, both of those people will sort of have a happy medium of people who can judge the trial fairly. So, voir dire is the process in which both sides' attorneys ask prospective jurors questions to determine whether any potential juror is biased or has any connection with a party to the action or are potential witnesses. If my dog bit your kid and your grandma's up on the jury box, she's not going to side with me, she's going to side with you. So I don't want that. If I have, if that same case, my dog bit your kid, you aren't going to want somebody who absolutely hates children and is like, they should all be bitten by dogs. You're not going to want somebody who's biased like that up there. So voir dire is the process where both sides get to sort of go through the potential jurors and toss out any that they think are going to be problems. Paralegals can assist in this process by drafting any questions that the lawyer should ask. They also are going to be watching for reactions to any questions. So if the lawyer asks a juror, do you like dogs? And then like another potential juror down the way goes, and like scoffs and laughs or something, you're going to make a note of like, don't pick that guy. You also may look up any info on potential jurors. If you're scrolling through a quick like Facebook check. Attorneys may challenge potential jurors' seat on the jury. You can have challenges for cause, which are an unlimited number, but you have to have a good reason. So, for example, if I was questioning a juror and that juror was like, nah, I hate black people, that's reason. I'm going to challenge that for cause. They should be kicked off. You can also have peremptory challenges. You get a limited number of these, but you don't have to have a specific reason. As long as it's not prejudicial, you get to be just like, I'm going to use one of my peremptory challenges, excuse that voter, thank you for your service. You don't have to explain, you're just like, nah. Now, if I see that the other side has kicked off all of the women jurors, I'm going to challenge that. I'm going to be like, hey, they're doing it for prejudicial reason. But as a rule, you get a certain limited number of freebies of I don't need to explain it, I just want this person gone. And so, both sides get to do this. So I might really want to keep this juror on because they're going to vote for me. And then the other side uses a peremptory challenge and they excuse that juror. And then I do the same to a juror that they like. And so that's how sort of our juror pool is weeded down to hopefully a fair and balanced jury for both sides. All right, so your duties during a trial. You're going to have to assemble any documents or materials that the lawyer is going to need in court. You're going to want to be monitoring witness testimony. You're definitely going to need the relevant deposition transcripts at hand or any deposition videos. And you also want to be observing juror reactions. You essentially are the attorneys. If you're there with them in court, you're their extra eyes. You get to be watching all the background players and sort of taking notes on what's happening. So, opening statements. Both attorneys give a speech about their brief version of the facts. This outlines the supporting evidence to be used at trial. It's sort of a summary of what's going to happen. It's a roadmap to the trial. The defendant's attorney has the right to reserve their opening statement until after the plaintiff presents the case. So essentially, the plaintiff gets up there, they say, hey, this is what happened, this is my case. The defendant's attorney has the right to be like, well, you heard him say all that stuff, and here's why it's hogwash. Like, they get to sort of refute the stuff that you just said. So, examination. You can have direct examination. This is the examination of a witness by the attorney who called them to testify. So basically, I get to say, I'm calling you to the stand, and now I'm talking to you. Cross-examination is the questioning of that same witness by the opposing counsel. So the plaintiff calls a witness, and I talk to them. Now the defense gets to talk to them as well and be like, hey, don't flim-flam me, buddy. This isn't what you said. Then redirect is the questioning of a witness following that cross-examination. And recross is the same thing. So essentially, when it comes to examining a witness, pardon me, during trial, we sort of have a philosophy of, I go, then you go, then I go, then you go. That way, you don't just get to leave a question hanging in the air, you get to answer it. So then we come to closing arguments. Both attorneys summarize their presentation. Closing arguments, you're really arguing in your client's favor. You want to include all the major points, as well as emphasizing the shortcomings of the other case. So you're going to have like, well, I know the client said this, but really this is what you need to do, and this is why my client's innocent, and oh, they're so bad, and I'm so amazing, blah, 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 blah. So, once a jury has been selected or seated, the trial begins. Once the jury reaches a decision, the jury issues a verdict in favor of one side or the other. The jury's then discharged. They've done their duty. After that, the court enters a judgment. So you can have things like the jury says guilty, not guilty. Then the court, usually the judge, will say, okay, you've been found guilty. You have to pay $1,000 and you can never wear the color blue. That's going to be the judgment. That's sort of, you have to pay this money, or you go to jail for this many years, or you have to do this thing. So, it's important to remember jury is verdict, court is judgment. The two J's don't go together. All right. And so with that, that's basically it. I know, thanks everybody for hanging in there. This one was really long, but it is more or less a comprehensive final. Make sure to hydrate. Make sure to do lots of studying. And while you're at it, make sure to memorize the current United States Supreme Court. It's definitely, these are the keepers of our law. They are the highest court in our land. They are people you need to know. You don't want to be talking with an attorney at a job interview, and they're like, oh, so what did you think about the Supreme Court? And you're like, oh yeah, that Chief Justice Burger King, you need to know these people's names. This is also, these are some sweet bonus points for you guys to get. You need to know Roberts is the Chief Justice, and you need to know the last names of the rest of them. These are some easy, sweet bonus points. Like, anytime you can have an extra credit on a test, you should go for it, because, those are points where if you mess up earlier in the test, this covers it.
Do you know, is it one justice covers 1 point on the final, or how does it work?
I don't know off the top of my head what whatever Professor McKee has told you is the answer to that question. But I tend to remember them alphabetically. I also have, Chief Justice Roberts. I don't ever remember how I remember Alito, other than I've just heard his name. I always remember Stephen Breyer because of Breyer's ice cream, and he is like a vanilla white man. So that's how I remember it. Ginsburg is always in the news. Gorsuch and Kavanaugh both have very much been in the news over the years, so they're probably going to be easy to ping. Caden and Sotomayor are, Sotomayor, Kagan, and Ginsburg are the three women that are on the court currently. Clarence Thomas also has been in the news recently.
What's the president's case for the financial?
Yeah, so these guys have been in the news a lot. They hear a lot of cases. However you guys want to memorize them, but like please do. These are easy, no fuss bonus points. You don't have to remember like first names. You don't have to remember what their opinions are, whether they're conservative or liberal. You just have to remember 9 names and which one of them is the Chief Justice. So like easy bonus points. So with that, thank you all of you people who are hopefully watching this. Thank you two both for actually showing up. Thank you for your questions. You guys missed out. You got a lot of bonus info that I wasn't gonna say. So thank you both, and good luck everybody. And now I have to figure out how do I pause this. Perfect. Good luck.